So welcome back, everyone. We are going to change our agenda in just a moment because Judge Amadeo, who's the Chief Judge in Buffalo City Court, is here and wants to take this opportunity to speak to you a little bit about your involvement in the Attorney of the Morning program. And I just wanted to say thank you to Judge Amadeo. Over the years, he's been a very strong supporter of this program. His chamber's door has always been open to us when we're trying to work out policies and procedures that benefit our clients, that make the practice easier, and also allow the court staff the ability to do their jobs. So I just wanted to thank Judge Amadeo for all the support and assistance he's provided over the years, and without further ado.
It is afternoon, everyone. I'm Judge Amadeo. I'm the Chief Judge of Buffalo City Court. I've been there for 21 years, and it looks like after this election I'm going to be there for a little longer. I'm all set. November I need one vote, so if any of you live in the city of Buffalo, my wife's giving me a hard time. She says I got to take her shopping for that vote. That will be more costly than a whole election, so I'd appreciate your support. But I've been on the bench for 25 years. I've done landlord-tenant cases for 25 years, and many, many of them. Now, I want to first start off by thanking the 3 Gs. The 3 Gs have taken their time and their knowledge and sat here and given you some great advice here. But Jerry, Grace, Gail, thank you very much. You do a great job, and it helps our court. Then I want to thank you, because without you, one of the most important aspects of our court would go without any representation. We in Buffalo City, I can't even imagine the amount of cases. I probably have it somewhere, the statistic, how many cases come into our court for landlord-tenant, and you're talking about some place where a person lives. Some person has their family there, and it's very important that they don't disrupt their lives, and now they're being asked to leave. And quite frankly, the law provides for that to happen, and there are certain rights and regulations that we look at, and without representation, sometimes they just don't know what to say. And it's very difficult for us as judges to sit on the other side and represent them in our court. So it's up to you to walk into probably, I would say, one of the most, I say, how many do we handle on a day? 150 sometimes? With BMHA, it's like, I don't know, the traffic up there on the floor is amazing. But there's a sense to that traffic, and you make the sense when you do, when you come in. And we appreciate it, so thank you for all that you're doing. I see we've got some very new attorneys coming in to work here on there.
Please.
Oh, God. His brother used to sit on the bench at Buffalo City Court many years ago, and he went through the landlord-tenant. What we do in Buffalo City Court, there are 13 judges. There's going to be 14 starting January 1st. Judge Russell does not take special term, and the domestic violence judge, which is Judge Martocci right now, will not be doing special term work. Special term is set up in 13 different terms. So there will be 13 different judges. Most likely one term was usually done by acting judges from the towns and villages, but we're going to split that up among ourselves now, and we'll be doing it. So there'll be 12 judges that will be doing the special term, all different personalities. Some have different rules. You have to get used to them. But in all cases, you're gonna need some time out in the hall to get your cases together. And we understand that as judges, and I, as the chief judge, talk to them all the time about the time you need out in the hallway to get your case together. So you may feel rushed, but remember, we want to make sure that every person in our court feels like they've had their day in court. And that's what I try to emphasize with the judges who feel like it's getting near 12:15, 12:30, and we're still on the bench and they still have 2 cases out there. If you look at the statistics, and I think Gail told me, how many cases did we handle? You handled, I think it was...
Judge, let me get it, sorry. Here it is. Judge, we handled, in the past year and a half, 2,116.
Out of 2,116, that's close to 1,700, 1,800 cases that were settled for the judges. You realize that settling those cases for the judges and not have to have a hearing allows us to put that many cases on the calendar and service the people in Buffalo. So what you do is important to our court. We can't function without you. Now, I feel that way, and my judges all should feel that way. Our chief judge came to our court last year, and he wasn't coming to see our court. He was coming to talk to us about some other issues, and he was visiting, so he stopped in our court. It happened to be on a day when we had the attorneys of the morning working with BMHA. So there was chaos out there. But he saw chaos being represented. And it was the best thing, he says, I've ever seen, because they don't have that in New York City. They don't have what we have here. We have a good bar. In fact, you represent many landlords. However, those landlords, those attorneys that are representing landlords know how to work with you. We're not cutthroat here. In Erie County, we work together. Now, you're going to come in front of a judge, and that judge is going to sit back and say, I want to get moving, I want to get going. You do your job. If you've got a problem, and the problem surfaces to something, keep your mouth quiet and come and see me. I'm always there, my door is open. You see Jerry, you see Grace, they'll come and see me, all right? That's a promise to all of you. And we'll work it out. There's no reason why we can't hold our temperament on a bench when the volume is so high that we infringe on the rights of those people that are coming before us. And that's what I feel. We have an obligation to make sure that those individuals coming before us have their day in court. And you're the ones that are going to be doing it. So I want to see, I'm trying to think if there's any. Habitability hearings are a big thing. You're going to get a feel for that. You're going to find that there are tenants that are habitually in our court. Why? Because they're always they go in, they know a system of how not to pay, and they make that payment, and they come in, and they habitually come in, and they know the first thing they got to do to stay there a couple more weeks is say, let's I can't live in that place. And you're going to have to get a feel for those type of cases. And then there are people where the landlords are absolutely don't put a penny into their properties, and they're falling apart. What I had done before, and this is just to show how much I care, I took all the landlord-tenant cases and I put them into housing court. Now, technically, I should be doing them in housing court. There's a statute in 1978 that says that part of the housing court that they created should do the landlord-tenant cases too, but It's impossible for one judge to do that. What I did was I had a hearing officer, one of the attorneys, handle all of them on a sort of like a pretrial basis, and he resolved, I would say 95% of them, and then the other 5% went to the housing court judge. When we lost all our funding, we got cut $100 million, $170 million in the court system in New York State. Many people got laid off, and one of them was the attorney that was doing that, and I haven't been able to replace him since then. The economy's never gotten so I could do that. If I was ever able to get that situation going again, it would make the perfect situation for you, especially in the cases of hearings on habitability, because the housing court judge has access to a lot of material as far as the house is concerned, if it's in housing court, if there's a lot of violations, and that would give you a good clue on whether or not that house is in good shape or not. So, again, I want to thank you for all you're going to do. 7th floor, room 750. You have a problem, you come and see me. Don't worry about it. Patty's my secretary. She'll let me know, and you'll come in, and we'll resolve whatever difficulties you have. I don't think you will find too much there. You're going to be too busy to find difficulties. And trust me, the amount of cases, we're going to sit down and we're going to talk about some procedures and that we might try to put in place, because we want to see that more people, the most amount of people, get representation, and it's important to us. Our chief judge came to see it. He just can't believe it. He's very happy with it, and you know he is the one that is promoting legal representation for the poor in civil cases. So, again, thank you for all you're going to do, and if you don't have gray hair, you will get some, just by one term in a special term. So thank you. I have to go learn, so we're trying to get, right now the county and several people throughout the different governments are trying to put their finger on best practices for mental health patients and people that are on the street in confrontation, better alternatives than arresting them and putting them in jail. And so we're meeting over there, brainstorming with the county and several people from the state, and I guess the governor wants to help out a bit on it. So let's hope on that too we work it out. Thank you very much. Thank you for all you do.
All right, let's get back to the meat and potatoes
Yes,
of our work here. Rolling up our sleeves and looking at holdover petitions. So as I said earlier, non-payments, they're the most common. Holdover petitions are brought in several situations. So it could be that there's a lease agreement that's come to an end, and the tenant remains, they're holding over, the landlord wants to evict. It could be there is a lease agreement that the landlord feels was violated. One of the terms of the lease were violated. The landlord sent the necessary notices under that lease. Maybe the tenant doesn't feel that they violated the terms of the lease. The tenants remain. It could be that it's a month-to-month tenancy. And in a month-to-month tenancy, the real property law says the landlord has to give a full term notice. So what does that mean? A lease agreement might say, if you violate this lease agreement, tenant, I have to give you, as the landlord, a 30-day notice. That's exactly 30 days. On November 3rd, I can tell you, tenant, I would like you out by December 3rd. But if it's a month-to-month, if it's an oral lease agreement, or even if it's a written month-to-month that doesn't talk about how the lease will be terminated, then the landlord has to give a full calendar period, or a full term. So what that means is, if the rent is due on the 1st, the landlord has to tell the tenant by the 31st, before the 1st of the month, that the landlord wants the tenant out at the end of that term. So the landlord cannot, if the rent's due on the 1st, the landlord cannot tell the tenant on the 1st of, let's say, September, I want you out by October 1st. The landlord has to tell the tenant by the last day of August that they want the tenant out by the end of September. And if the landlord's notice is untimely, then that's a basis for getting the petition dismissed. And most judges will consider that as a valid defense. So let's go over holdover proceedings. Go ahead.
With the month-to-month, how does that work with rate increases?
With rent increases?
Correct.
So the notice cannot be, Jerry mentioned before this notion of equivocal notices. So the landlord cannot say, dear tenant, I'm going to raise your rent, let me step back. It's August 31st, and the tenant receives a note that says, dear tenant, I am going to increase your rent by $300 effective October 1st. If you can't pay this increase, you have to leave. That's an example of an equivocal notice. The landlord is giving the tenant a choice. Either you pay the increase or you go.
Can't be unilateral.
And also, as Jerry mentioned before, the rent increase can't be unilateral. So if the tenant pays the increase but objects, the payment is considered sort of an acquiescence or an agreement. But if the tenant never pays the increase and then the landlord says, oh, well, I'm going to bring you to court as a holdover because you're here and you didn't pay the increase, your argument as the tenant's attorney would be no. This was an equivocal notice. It gave the tenant a choice, pay the increase or move, and the tenant actually didn't have to do either because it was equivocal and the underlying notice did not meet the requirements of the RPAPL or the RPL. So the termination notice has to be clear and unequivocal. Go ahead.
So what would be the
How
right
to
type
do
of
that?
notice to raise the rent?
So it should be probably two separate notices, or the landlord has to decide which course of action he or she wants to take. The landlord has to give 30 days notice of a rent increase, unless he just gets, or she just gets the tenant to agree. But the landlord could give notice of a rent increase, and then when the tenant says, I'm not paying that, then they could give a notice of termination if that's what they wanted, in fact, to do. Or the landlord could say, let's say on the first of the month, let me rephrase that. The landlord could say at the end of the month, I want to increase your rent in 30 days. And the tenant says, no, I can't afford that. Then the landlord could bring a notice that says, I am terminating your tenancy. But doing it in the same notice is problematic. Similarly, you're the landlord now, you have a tenant who has crazy parties until 3 in the morning and all your other tenants want to move out. So you send a note to your tenant, please stop the crazy parties, or your tenancy will be terminated. You can't rely on that notice as the basis for the holdover. You've given the tenant a choice.
As a landlord's attorney, I recommend to my clients, not if they're terminating a monthly tenancy, not to give any reason, because there's none required. So that if you see a termination notice that doesn't give a reason, don't think that you have a valid defense to that. If it's a month-to-month tenancy, then in fact you need give no reason. And if it's the expiration of a term, you don't even need to send a notice. You can just bring an eviction proceeding. If your lease ended on December the 31st and the tenant was still there on January 1st, on January 2nd you could start an eviction proceeding without any notice whatsoever.
If there is a lease agreement, then the termination has to cite the specific lease provision violated. So as Jerry mentioned, if it's a verbal month-to-month and oral month-to-month, you don't need a reason. Look at the tenant's lease, but most leases will say, some leases will say, the landlord has the right to terminate this lease agreement with 30 days notice. Some lease agreements actually say that.
Most times they don't bring their leases to court.
That's a problem. Most tenants don't bring their leases to court. The burden would be on the landlord to establish that he or she met the requirements of the lease agreement. So look at the lease if your client has it. If you don't and you can't resolve the issue, you might ask the landlord or the landlord's attorney for a moment to review the lease. Some pro se landlords will say, I'm not giving you that paperwork. Just tell the judge you need to take a moment to look at the lease agreement. But if there is a lease agreement, the landlord has to include, pursuant to statute, to case law rather, the section of the lease that was violated. So the termination notice when there's a lease agreement can't just say, tenant, you violated your lease. There has to be something in that termination notice that says, paragraph 26 says you can't have a dog, you have a dog, that's a violation of your lease agreement, we're giving you notice. And the lease agreement may say it's a 10-day notice, it could be a 5-day notice, it really depends on what the lease provides.
Can I interject? Sometimes you don't need, some leases say without notice, you don't need notice as well. Be aware of that, but however, there are other leases, and I find them, as a landlord's attorney, disturbingly common, and that is that there's 2 notices required. So be aware of that, because sometimes the leases will say, if you are displaying objectionable conduct in some way, you would be served a 10-day notice to cease that conduct. And if you fail to cease that conduct, you'll get another notice for X amount of days. Make sure that you're aware, if there is a dual notice like that both the notices have been met.
I just whispered to Jerry, we have 3 minutes. Okay, holdover proceedings. If the landlord tells the tenant that the tenancy has terminated on a specific date, let's say October 31st, landlord sees that the tenant is still there on November 1st, offering the rent money. Oh good, I can take the rent, I'm not going to be out a month's rent. Landlord cannot do that. If you tell the tenant that the tenancy is terminated, and before you serve papers on the tenant to go to court, the notice of petition, and you accept rent, then you're deemed to have started a new tenancy. So there's this window period, and it's the period after the tenancy was terminated, but before the eviction proceeding was initiated, if rent was paid by the tenant or on the tenant's behalf. Social services sent a check to the landlord. Now, it could be partial rent, it doesn't have to be full rent. It could be rent sent by a third party, an agency on the tenant's behalf, and retention of rent for a long enough time. If the landlord holds on to the rent check for 3 days and initiates the proceeding, then retention might not constitute acceptance. But holding the check, not just negotiating the check, holding the check is considered acceptance of rent as well. I'm going to zip quickly through illegal use. An illegal use proceeding, it's often brought under what's called the body house law, and the sense is that you, the tenant, are using the residential property for an illegal use. In the body house days, it was usually a house of prostitution. In more modern times, you're using it as a crack house. The burden on the landlord is very, very high, because there's no notice requirement other than that you serve the notice of petition and the petition on the tenant. The landlord has to show that there is ongoing, not just last month, but today, continuous illegal use. So the fact that the tenant is smoking pot in the living room, that's not using the premises for an illegal trade or business. But if the landlord walked into the house, no one was living there, and there's like the little peepholes and the place to slide the money and get the drugs, then that's probably illegal use. Those are easy to get resolved or get tossed. The reason why is the landlord often cannot bring in the witnesses to us. Even law enforcement, unfortunately, is not often cooperative. So the landlord has a really hard time bringing in the witnesses that the landlord needs to establish ongoing, continuous illegal use. So often the tenant doesn't show up in those situations. But if you get one, sometimes it's the wrong person. You know, it's the back house.
I know we're pressed.
I know, go for it.
Just if anybody wants to ask about, oftentimes a landlord will bring an eviction proceeding because they've received a notice from the city that there's an illegal trade going on in the premises. We can talk about, I'll stick around, we can talk about that particular type of notice later, because often you may get a landlord that said, I have no choice but to bring this proceeding. So we'll talk about that because we're time pressed right now.
Foreclosure-related evictions in 2009, there was federal law enacted, the Protecting Tenants at Foreclosure Act, and there was also state law that was passed. This allows, it doesn't protect the prior owner. So you're going to see cases where the respondent was the prior owner, and the new owner is bringing an eviction action to get rid of the old owner. In that situation, it's Real Property Actions and Proceedings Law Section 713.5 that comes into play, and the new owner must simply exhibit the original deed or a properly certified copy of the deed to the previous owner, and that's enough to start the proceeding. But in a case where there's a tenant, and it's, you know, it can't be the tenant can't be the prior owner's sister or wife. When there's actually a tenant in the property and there's been a foreclosure, the successor in interest, the bank, for example, has to let the tenants know before the foreclosure process even begins that the foreclosure process is about to begin, and has to notify the tenants as to what their rights are. Even month-to-month tenants get 90 days. They're entitled to a 90-day notice. People with lease agreements, tenants with lease agreements, have 90 days or till the end of their lease, whichever is longer. The exception to the rule is where the successor of interest or the buyer of the property is someone who's going to move into the property, and then it's a 90-day notice requirement. The tenant has an obligation to continue to pay rent, so if the tenant simply stops paying rent, that 90-day protection does no longer exists. Or if the tenant does something to violate the lease agreement, then the successor in interest can bring an action based on the violation of the lease. You may run into situations where there's a rent-to-own, and really what you need to look at in these situations is how much equity does the tenant have in the property. So you may look at an agreement, and you can often ask for an adjournment in these cases. You can adjourn it so that NLS can take the case, and we can look at the documents, because sometimes the rent-to-own document is a little thicker than you have time to review. But if you see a document, it's a lease and rent-to-own, and it says the tenant is going to pay $500 a month, $50 is towards the purchase price, and the other $450 is for rent, and they've only lived there for 2 months, then they have $100 worth of equity in that property, and the court's going to treat it like a landlord-tenant matter. But if the tenant has lived there for 20 years, and they've paid taxes, and they replaced the roof, and they replaced the furnace, then this starts looking like something that should not be resolved in a summary proceeding. It may be a foreclosure action, it may be an ejectment in Supreme Court, but a summary proceeding is not the proper vehicle to terminate the relationship. I will talk very quickly about emergency assistance. Your clients are low income. Many will be eligible for assistance through the Department of Social Services. You might want to ask the landlord for an adjournment so your client can go to the Department of Social Services to see if they qualify. A little of it depends on the client's income and whether they've been helped before. So Department of Social Services will generally help people only once every 5 years. Unless your client's source of income is SSI, then they'll help once a year. Department of Social Services can pay up to 6 months of arrears. And for people who are on SSI who can be helped once a year, they'll go back 4 months. It's worth getting an adjournment if the landlord is interested and willing, so that the tenant can go to social services and apply for these benefits. You should at least try to get 3, 4, 5 days a week for that to happen, because there's often a long line there. If at the end of the day your tenant is evicted, and there's an information sheet in your packet that looks like, I'm not going to look for it now, but it has Department of Social Services written on it. They can also help with moving expenses. If your client doesn't have a car and doesn't have any money, they're going to be hard-pressed to get their household's possessions out and stored somewhere into their new apartment. They might not have one. Social Services can move people's possessions, and they can put it into storage. So at least you can prevent your client from losing everything that they own. Quick few words on settlement agreements. You have a form stipulation in your materials. There's a few things that aren't on this form, and they're not there for a reason. I'll explain what those things are. There's nothing in here that says that in the event that the tenant, the respondent, defaults in any payments that they may agree to make, that a money judgment will be awarded to the landlord. Why isn't that in the form? Because if we haven't negotiated that, and the landlord gets the form and he sees that there's not an X in the box of the landlord's attorney saying, oh, you'll get a money judgment if the tenant defaults, then the landlord's going to say, oh, and I want the money judgment too. So we don't put it in the pre-printed form. If the other side asks for a money judgment, though, that's obviously something you have to talk to your client about. You might want to let your client know after you fill out this form that the landlord may insist on a money judgment, because coming back to your client with new bad news at the end of the negotiation process may scuttle the deal. So you want to let your client know, we didn't put this in the papers, but when I bring this to the landlord's attorney may say, oh, there's nothing in here about a money judgment. We want that in there if the tenant misses a payment. The other thing that you should add, it's sort of my pet peeve, but I always include language, both in holdover cases and in non-payments, that say something to the, if it's a non-payment case and the tenant is going to be making regular payments, that the above monies once paid represents all monies due and owing through whatever date. I try to put that in stipulations that involve holdovers as well. Why is that? The lease agreement may say something about attorney's fees, and the landlord may have the right to go after the tenant, even after you've entered this agreement, may have the ability to go after the tenant in small claims court to collect those attorney's fees if they're in the lease agreement. If you didn't look at the lease agreement or your client didn't have the lease agreement, you might not know that, and you don't want to leave the door open to another action for attorney's fees or even for court costs and other costs associated with the tenancy or with the eviction. So put in your stipulations that, you know, no monies are due and owing, or all rent monies and fees are paid through, you know, such and such a date. Try to protect your client in that kind of way. One more thing about settlement agreements. Sometimes landlords will want tenants to agree to things like maintaining the property, or I'm just looking for I just saw an agreement a little while ago where the tenant agreed to maintain the premises to the landlord's satisfaction, and if she did not, then a warrant would issue. Well, that's really subjective, and it's giving the landlord a lot of power. You know, if the landlord says, "Ooh, there's dirt on the driveway, this is not met up to my standards, and my agreement says I can put you out if there's dirt in the driveway," you're going to be hard-pressed as the tenant's attorney to try to establish that the landlord had no right to put out the tenant. So things that you can measure easily, $500 by January 5th, absolutely. The tenant doesn't do it, there's an eviction. The tenant's going to get rid of their dog by December 12th. That could be a little grayer, but chances are that's something that you can hope to prove or disprove. But keeping the driveway clean, you probably don't want to agree to a warrant if the tenant doesn't do that. Any questions? All right. Well, thank you, everyone. Thank you for agreeing to participate. Jerry and I are happy to answer questions if anything comes up, either while you're serving as the attorney of the morning or even this afternoon.
Very quickly, would you please take a few seconds to fill out your evaluation form? Thank you for your time. I know we went over a bit. There's a ton of information, but what I want to let you all know is that you don't operate in a vacuum at the Attorney of the Morning program. You are assisted by Christine Sanchioni, who's so skilled. We have volunteer law students. We have other paralegals from our office who are over there. It's a real community, and we want you to enjoy yourselves, and you will, and you'll have a good time. You'll get an opportunity to network with attorneys, and you'll be doing good for the community. Thanks so much.